Today we have to talk about the text of the Second Amendment, because the text of the Second Amendment gives us the unqualified command against the government to not infringe upon our right to keep and bear arms. And the good news is virtually every single critical word in the Second Amendment itself has been defined by none other than the U.S. Supreme Court using 18th century definitions at the time of our founding. Stay tuned. We're going to break this down. You're going to really enjoy this. You're going to learn a lot, and you will be armed to the teeth when it comes to defending our rights against the anti-gun lobby in America. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks. The U.S. Supreme Court in Ancillary v. Bruin and also in Heller made clear that the critical component of the Second Amendment is the text itself. The plain text analysis is what it's sometimes called. The Second Amendment is an unqualified command, an unqualified textual command. That's not what I have to say about it. That's what the United States Supreme Court has called it, an unqualified command. Makes a lot of sense, right? Because the ultimate historical document, the ultimate historical proof that the founding fathers of our Constitution, a Constitution that is followed and sworn to, people swear oaths to it today, included the Second Amendment. The right of the people to keep and bear arms shall not be infringed. It is the governing document. The Constitution is the key document, is the supreme law of the land. Any law, federal, state, or otherwise, it is inconsistent with the United States Constitution, including the Second Amendment, must fall by the wayside as being unconstitutional. Now, what does all that mean when it comes to the meaning of the words of the Second Amendment, the right of the people to keep and bear arms? For the purposes of this video, I'm not going to talk about the prefatory clause dealing with a well-regulated militia. We don't need to. We can in a separate video, but we don't need to because the Supreme Court has already said that the operative clause, the right of the people to keep and bear arms shall not be infringed, is perfectly consistent with the prefatory clause. So we don't need to get into the militia for the purposes of today's video. Let's just talk about the words of the rest of the Second Amendment, the operative clause, as defined by the U.S. Supreme Court. To begin with, it's important to understand the importance of the text and why we got to be careful. The anti-gun movement, as we've talked about before, the anti-gun litigators want to elevate every single controversy, every single debate, whether it be in common use in an arms ban case, whether it be a historical tradition as to whether or not 18 to 20-year-olds can carry guns outside the home in public, whatever it is. The anti-gun movement wants to elevate every single conceivable controversy and litigation and fight about the Second Amendment to the textual level. Because as you know, at the textual level, the Second Amendment plaintiffs, the person asserting the Second Amendment right, bears the burden, which is not a very difficult burden to meet, of just showing that the modern-day gun control law is being implicated by the Second Amendment's text, and thus the conduct that the Second Amendment proponent either engaged in or wants to engage in is somehow being infringed upon and is implicated by the text of the Second Amendment, which is prevented from being advanced or is otherwise being hindered by the modern-day gun control law. Once the text is implicated, you know what happens. The burden shifts to the government. It's a very heavy burden to show a long-standing historical tradition of regulating firearms in a particular way consistent with the modern-day gun control law. So the anti-gun movement desperately wants to make sure that the burden of proof never shifts to the government, because the reality is once the burden of proof shifts to the government to prove the historical case of a modern-day gun control law, it's extremely difficult, because the reality is throughout American history, at least up until the late 20th century, there were very few gun-related laws on the books because it was viewed as a fundamental individual right that could not be infringed. And only with the rise of the anti-gun movement and the progressive era and the FDRs of the world in the 20th century do we start to see the obvious view that peaceably using and carrying guns was just understood to be a fundamental right, which is why it's in the Bill of Rights as the Second Amendment. Okay, so with all that said, let's focus on the text of the Second Amendment, and because this is not an academic exercise, the broader the text of the Second Amendment is, the more likely it is that a modern-day gun control law will be implicated or will implicate the text of the Second Amendment, which shifts the burden to the government. So the broader the definitions of the Second Amendment are, the better it is for the Second Amendment community. And we always want to make sure that the historical analysis, where the burden is on the government to prove, does not get elevated into the textual discussion of a litigation, because that means the burden at the textual level is not on the government just yet. So this is why I want to talk about the scope of the text of the Second Amendment, because it's very broad and very helpful. And again, all we have to do at the textual level to show that a modern gun control law is implicated by the plain text is just show they touch fingers with each other, and that shifts the burden to the government, which is always where we want to be. Okay, so let's just talk about what the Second Amendment covers. To begin with, the Second Amendment talks about whether or not someone is part of the people, whether or not a proposed course of conduct it falls within the definition or the verbs of to keep, which means to possess, or to bear, which means to carry, and of course, what constitutes an arm, and relatedly, what constitutes an infringement. Thou shalt not be infringed, right? So what is an infringement? So let us begin with the basics. Again, to begin with, the people means at a minimum all Americans. You see, there are 6 other provisions in the United States Constitution that mention the phrase the people. And that term absolutely refers to all members of our political community. The most important case as to who the people are arose in the 1990 case of the United States versus Verdugo. In the Verdugo case, this is what the Supreme Court said. Quote, "The people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and Tenth Amendments, refers to a class of persons who are part of a national community, or who have otherwise developed sufficient connection with this country to be considered part of that community." So that's the Supreme Court, what they said in Heller, quote, in that Verdugo case from 1990. So at a textual level, the people in the Second Amendment refers to, at a minimum, all Americans, not just good Americans, not just moral Americans, not just tall Americans, not just mean Americans, not just happy Americans. All Americans fall within the definition of the people, just as they do in the First Amendment and the Fourth Amendment. And remember, the Fourth Amendment, which is a criminal procedural protection, deals with people who are not, the government is not allowed to engage in warrantless searches and seizures, or unreasonable searches and seizures, or warrantless searches, and so on and so on. A lot of the people that benefit from those protections are not really good people. They're not nice people. A lot of them are very thuggish, violent criminals, and yet they're still part of the people. So anytime somebody says that anybody other than all Americans are protected by the right of the people to keep and bear arms, so then you just ask them, does that mean that children are not protected by the Fourth Amendment, or old people are not protected by the Fourth Amendment, or evil people are not protected by the Fourth Amendment, or women are not protected by the Fourth Amendment, so on and so on and so on, whatever you're talking about? Because the reality is the people in the First Amendment, the people in the Second Amendment, the people in the Fourth Amendment, and so on are referred to all American citizens, all the individuals in this country. And by the way, as a side note, when you get into these debates about can you take away guns from those that are violently dangerous Americans are part of the people at the textual level. So the only way that the government can take away a gun from a violent criminal is not at the textual level, the right of the people to keep and bear arms shall not be infringed. It's after the burden has shifted to the historical level, to show there's a long-standing tradition of, for example, putting violent criminals who've been convicted after due process in prison and disarming them while they're in prison. Well, that's a long-standing tradition. But again, the question about who can lose their gun rights temporarily or otherwise, that is not a question of the text. That is at most a question of history, where the burden is on the government. You see the issue? So all Americans are textually part of the people, but some Americans can lose their right to keep and bear arms at the historical level. For example, if they go to prison for committing murder, that would be an example where when they're in prison, they can't have guns, just to illustrate the point. But let us carry on. Let us turn to the next definition, arms, right? Arms is really quite simple. Arms refers to anything that can be used offensively or defensively. Now, the Supreme Court defined this in the Heller case. Specifically, how did they do it? They used founding era dictionaries that were around that existed at the time of the founding of 1791 when the Second Amendment was adopted or shortly thereafter. And they looked to dictionaries put together by founding era lexicographers. They specifically focused on three. They focused on the famous English lexicographer, dictionary maker named Samuel Johnson. They focused on Noah Webster, who wrote the first American English dictionary. Samuel Johnson did the English dictionary, and Noah Webster did the American English dictionary a little bit later. And the Supreme Court also relied on the definitions of some of the words in the Second Amendment from a famous dictionary maker, also Timothy Cunningham, who wrote a very important 1771 legal dictionary for lawyers. It doesn't really matter because at the end of the day, they all defined arms essentially the same way. Samuel Johnson defined arms as, quote, weapons of offense or armor of defense. Timothy Cunningham, he defined arms as, quote, anything that a man wears for his defense, or takes into his hands, or useth in wrath to cast at or strike another. I should also note that Noah Webster in the early 19th century had basically almost an identical, very similar definition of arms. Not a lot of controversy as to what an arms is textually. It's basically any kind of weapon or body armor or armor, right? Anything that can be used offensively or defensively is an arm for the purposes of the text of the right of the people to keep and bear arms. So we've covered the right of the people, as all Americans, now we have to talk about to keep and to bear. These are actually very simple. To bear means to carry, and to keep means to possess. Specifically, Samuel Johnson defined to keep as to retain, not to lose, to have in custody. While the American lexicographer of American English dictionaries, Noah Webster, defined to keep as to hold or to retain in one's power or possession. And of course, we know what to bear means because the large part of the Bruen case was about to bear. There was a big debate. What did bear allow, and did it allow you to carry guns outside the home? And the answer is undeniably yes, because to bear means simply to carry. That goes all the way back. Everyone understood that to bear means to carry. Very basic term. And again, the question in Bruen was, does the right to keep and to bear, two separate things, does that cover the right to carry guns in public or just to carry them privately? Of course, the Supreme Court essentially, for a whole host of reasons, said it would be absurd to think that to keep, which means to possess, is somehow the same as to carry, because among other things, that would violate a rule called you cannot render terms in a legal document to become nugatory, which means irrelevant or to read out of them. So if you were going to read the word to bear the same as to keep, meaning that, well, to bear means that you can carry a gun from your bathroom to your living room to your bedroom to your kitchen, you can bear arms that way. That seems a whole lot like to keep, where you keep your guns in your home. So the Supreme Court says obviously to keep means to have the guns in the home, and to bear means to have guns outside the home. And of course, there was a whole lot of other history that went into that. But the bottom line is the people is all the people of America. Arms is anything offensively or defensively. To keep means to keep, to possess. To bear means to carry, which gives rise to what's left. We know what's left. It shall not be infringed. Well, the Supreme Court, interestingly enough, has never specifically defined what infringed means in the Second Amendment. But that's not a big deal because we essentially can figure it out by virtue of looking at the same dictionaries, the same founding era sources that the Supreme Court used to understand the rest of the Second Amendment. Specifically, we look at how Samuel Johnson, the English lexicographer, defines to infringe. We look at Noah Webster, the American English lexicographer, as to how he defines the word infringe, and so on and so on. And we know what infringe now means, which is not a heavy lift. It means to destroy or to hinder or to destroy. That is what Noah Webster and Samuel Johnson both defined it as. So are we missing here in our talk about the text of the Second Amendment? Well, there is one thing we are missing that we need to talk just a few minutes about, and that is ancillary rights. Those are rights that are implicit or necessary for the effectuation of the right of the people to keep and bear arms. The best example I like to give is in the First Amendment context, just to illustrate the point. In 1983, the United States Supreme Court, in a case called Minneapolis Star, which we've talked about before on this channel, held that it was unconstitutional to have a targeted tax on ink, because ink was used by publishers to publish newspapers, to effectuate or to allow them to exercise their right to a free press under the First Amendment or the right to free speech under the First Amendment. And ink was a central component or needed or one thing that you could use to protect the right the right to free press or the right to free speech. And because a targeted tax on ink hindered or restricted the ability to engage in these activities, it was knocked down as unconstitutional in the 1983 Minneapolis Star case. So that's the kind of thing we're talking about. Now, this becomes an issue in the Second Amendment context because sometimes you have a litigation involving, for example, bullets. Are bullets protected by the Second Amendment? The word bullet does not appear in the text of the Second Amendment, but obviously you need bullets for arms to be effectuated, for them to be effective. And if you take away the right to have bullets or you tax bullets, you're hindering, meaning to infringe, the right of the people to keep and bear arms. So too, for example, the right to train. It makes no sense to be able to have the right to keep and bear arms but not be proficient in their use. And of course, that's consistent with the well-regulated militia concept. We Americans have the right to train. Now, the right to train is not mentioned expressly in the text of the Second Amendment, but because if government denies people the right to train with their arms, it makes them less proficient. And the Supreme Court has cited favorably the Ezell case out of the Seventh Circuit, and the Ezell case held the right to train. So in addition to, for example, the right to bullets, I think the right to a barrel, I think the right to a trigger, the right to a firing pin, the right to train, I think there's other things out there we can think about in terms of these ancillary rights. For example, the right to make your own gun. Well, you can't keep and bear arms if you don't first and foremost acquire guns. Obviously, one of the ways you acquire a gun is you can make your own gun or you can buy a gun. So if you have anything that hinders or restricts your ability to make your own gun or to buy a gun, obviously that is an infringement because, again, as we know from 18th century lexicographers, to infringe means to hinder or to destroy. So if you're taxing the ability to get a gun, if you're making it hard to acquire a gun either from an FFL or to make your own gun, these are hindrances as defined, and thus they are infringements as defined in 1791, because again, to infringe means to hinder or to destroy. All right, folks, well, I hope this is helpful. But again, these definitions are very broad and they're very helpful because, again, once these definitions are implicated by a modern-day gun control law, the burden shifts to the government. And we always want the burden to shift to the government, and means you and I can look out the window and watch birds while the government tries to come forth with a bunch of historical analog laws, which they're simply not going to be able to do. The anti-gun movement in America has been trying to take away our rights for decades and decades. They've been searching and researching and looking at the history for decades and decades to find every conceivable argument, every conceivable historical analog law that they can use to basically say that we had no right to keep and bear arms, and they simply haven't come up with anything. In fact, if you look at the history, of course, we know the reality is the right to keep and bear arms is a fundamental right. That's why it's in the Bill of Rights, and the history underneath it at the federal level, the state and local levels, all is consistent with the notion that this is one of the most fundamental rights, and any restrictions or hindrances on that right is simply would be not just viewed as unconstitutional, but simply absurd and crazy. All right, folks, hope you learned something here today at the Four Boxes Darn It. Make sure you follow me on X at Four Boxes Darn It and subscribe and resubscribe. People keep getting knocked off our channel, so I'm told. So please help out on that, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.